Court strikes down a New York gun law making it easier to carry a concealed weapon in public.
The Supreme Court said that the Second Amendment does provide an individual right to have a gun.
We have a Second Amendment because we understand in this country that there are some things that you cannot justly take away.
States cannot put these special restrictions on getting a gun for a concealed carry permit.
Some of those more populous states, those states that require that extra hoop that you have to jump through, that's unconstitutional.
Would respect that precedent.
Yes, Senator. All precedents of the Supreme Court have to be respected.
I don't think this was entirely a surprise that it came down this way, but it is potentially a momentous decision.
The Supreme Court satisfactorily destroyed the system that let government bureaucrats deny your concealed carry permit just because they didn't feel like approving it. That system is dead, unconstitutional, gone in every single state in America. The case is New York State Rifle and Pistol Association v. Bruen, decided June 23, 2022, 6-3. Justice Clarence Thomas writing for the majority. And if you carry a firearm or have ever been denied a permit, I'm going to break down exactly what this means for you right now. Here's why you need to care about this personally. If you live in New York, California, New Jersey, Maryland, Massachusetts, or Hawaii, your rights just expanded more dramatically than at any point in your lifetime. Over 100 million Americans, roughly 1/3 of the entire country, lived under permitting systems where a government official had total subjective discretion over whether you were allowed to exercise a constitutional right. You could be a law-abiding citizen, clean record, completed every requirement, and still get denied because some bureaucrat behind a desk decided your reason for wanting to protect yourself wasn't compelling enough. That is no longer legal. And even if you live in Texas or Florida or any state that was already permissive, Bruen locked your rights in constitutionally, so no future legislature can slide you backward. This affects everyone, every state, every gun owner, and the people most impacted still don't know what happened. Alright, so let me walk you through exactly what the court did and why it matters so much. For over 100 years, several states operated under what's called a may issue permitting system. May issue means the government may give you a permit if it feels like it. New York had the Sullivan Law, which required you to prove what they called proper cause. You couldn't just say you wanted to protect yourself. You had to demonstrate a special need for self-defense distinguishable from the general public. California had a good cause standard. New Jersey had justifiable need. Maryland required good and substantial reason. Hawaii barely issued permits to civilians at all. In practice, this meant regular people got denied while politically connected individuals and celebrities got approved. If you were a night shift worker walking to your car at 2 a.m, if you were a small business owner who'd been robbed twice, if you were a single mother in a high-crime neighborhood, the state looked at your application and said, no, your fear isn't special enough. 2 men in New York, both law-abiding citizens, applied for unrestricted concealed carry permits for general self-defense. New York denied both of them. They sued. The case went all the way up, and the Supreme Court sided with them decisively. The core holding from Justice Thomas is simple. The Second Amendment protects an individual's right to carry a handgun outside the home for self-defense.
Gaining some traction in Congress that would make it easier to buy gun silencers or suppressors.
South Dakota law now includes new protections for firearm suppressor ownership.
Recently, South Dakota passed Senate Bill 2. This is a law declassifying gun suppressors as controlled weapons.
42 states allow private ownership of suppressors, but Massachusetts is not one of them.
The government cannot force you to prove a special reason to exercise that right. Self-defense is the reason. The Second Amendment is the reason you don't need another one. Now here's what most people completely miss about Bruen, and this might actually be bigger than the permit ruling itself. Before this decision, courts evaluated gun laws using something called intermediate scrutiny. Under that standard, the government just had to show a gun law was reasonably related to an important interest. They'd say public safety, cite some statistics, and win almost every time.
Court strikes down a New York gun law making it easier to carry a concealed weapon in public.
New York requires gun owners to give a specific reason they need to carry. The court said that violates the Second Amendment.
We are the lawful, legal citizens of the state. You know, most of us have training.
The sensitive places doctrine was not at issue in this case and still exists.
Nation's highest court has ruled that Americans have a right to carry firearms in public for self-defense.
I don't think this was entirely a surprise that it came down this way, but it is potentially a momentous decision.
Courts were rubber stamping gun control under that framework for years. Bruen threw that entire framework out. The new standard is what Thomas called the text, history, and tradition test. Now, when the government wants to defend any gun law, it has to prove that law is consistent with the historical tradition of firearm regulation going back to 1791, when the Second Amendment was ratified, and 1868 when the 14th Amendment applied it to the states. If New York wants to ban carrying in a park, it can't just say safety. It has to find a historical analog from the founding era. If it can't, the law is unconstitutional. That standard is now being applied to everything.
As a leader of New Yorkers Against Gun Violence, I have devoted my career to reducing gun violence in this state. I am committed to the safety of New Yorkers because I am a very proud resident of New York City. Advocate for strong, sensible gun violence prevention laws and policies. New York ranks 47th lowest out of 50 states in gun violence rates. We are the model for the nation on strong gun laws because it's not easy to acquire them here illegally.
Assault weapons bans, magazine capacity limits, waiting periods, red flag laws, all of them are being challenged under Bruen right now in federal courts across the country.
Thank you, Madam Speaker. I rise today in support of the Protecting Our Kids Act.
Declared something astonishing, which has electrified the country and left radicals seething. The Second Amendment protects an individual fundamental right weighed and decided upon by the people. 60 years of targeted destruction of the American culture by the secular and postmodernist left. Americans who have been watching will hear a familiar refrain in that jargon.
It's heartbreaking to hear how parents have to explain to their kids what to do if there's an active shooter. Enough is enough. We have to end the senseless deaths of our children and our neighbors.
Here's the critical context. Bruen isn't an isolated event. It's the third case in a 15-year progression that has been systematically expanding your rights. District of Columbia v. Heller in 2008 established that the Second Amendment protects an individual right to own a firearm for self-defense in the home. McDonald v. City of Chicago in 2010 applied that right to state and local governments through the 14th Amendment. And now Bruen in 2022 extended the right outside the home into public spaces and established the stricter historical test. Each case built on the last. The right started at home, got protected from state interference, and now exists in public with a constitutional standard that makes it dramatically harder for any government to restrict it.
The Supreme Court said that the Second Amendment does provide an individual right to have a gun. States cannot put these special restrictions on getting a gun for a concealed carry permit.
We have a Second Amendment because we understand in this country that there are some things that you cannot justly take away. In order to do this, Democrats in this body are willing to take away a citizen's God-given right, yes, God-given right. This bill, and it gets brushed aside, raise the age limit. Well, there are constitutional questions to that in the Fourth Circuit, Ninth Circuit, and other circuits. This will not do any good. It will harm Americans, and it undermines our foundational liberties that is crucial.
Core reason for the Second Amendment is to provide law-abiding citizens with the ability to carry a gun for self-defense. Some of those more populous states, those states that require that extra hoop that you have to jump through, that's unconstitutional.
More cases are already in the pipeline. The constitutional floor for your rights is higher now than it has ever been in the modern era. But let me be completely honest with you about what Bruen is and what it is not. Because getting this wrong could get you arrested. Bruen did not establish a right to carry without a permit. If your state requires a permit, you still need one. What changed is who can be denied, not whether permits exist. Do not start carrying without a permit because you read something online. Bruen also did not eliminate all gun-free zones. The court explicitly acknowledged that states can designate sensitive places like schools and government buildings. The problem is that states like New York and California responded to Bruen by designating practically everywhere as a sensitive location. Parks, public transit, restaurants, private businesses that don't post a sign saying guns are welcome. They're trying to make the permit useless by turning every sidewalk into a potential felony zone. Those expansions are already being challenged. Federal judges have blocked several of them, but many remain in effect right now in your state, and violating them is still a crime regardless of what Bruen says. And background checks, fingerprinting, training requirements, those are all still legal. Justice Kavanaugh's concurrence made that explicit. The government can still vet you, it just can't ignore you when you pass.
More and more shootings, it is getting worse and worse. Mass shootings have occurred in the workplace, on college campuses. States with laws requiring background checks on all sales have lower gun homicide rates than states that don't. We said our country needs a comprehensive strategy to dramatically reduce gun violence, and the Attorney General of the United States. Congress should also pass safe storage legislation to protect kids from being harmed by loaded weapons.
So here's where you stand right now. If you're in a state that was already shall issue or permitless carry, your rights are constitutionally locked in. No future legislature can drag you back to may issue. If you're in New York, California, New Jersey, Maryland, Massachusetts, or Hawaii, the old subjective denial systems are gone. You can apply, and if you meet the objective legal requirements, the state has to issue your permit. But those states are fighting back hard with new restrictions, expanded sensitive location lists, social media checks, and character reference requirements.
Right now, military spouses are not considered residents to be able to purchase firearms.
A decision by the United States Supreme Court that recognized the individual right to keep and bear arms under the Second Amendment.
There are people who travel around the country in RVs are today not allowed to use a post office box.
Would respect that precedent.
Yes, Senator. All precedents of the Supreme Court have to be respected.
There are 140 sponsors for this. I am most hopeful that this committee can bring this legislation up for action.
Gun rights organizations are actively challenging these in court right now. Laws are changing weekly in those states. You need to be checking your local and state laws consistently. Join a state-level gun rights organization because they are the ones filing the lawsuits, and they will alert you the moment something shifts. Your rights are expanding in real time. The trend line from Heller to McDonald to Bruen is unmistakable, and it is not stopping. But the difference between exercising your rights and accidentally committing a felony is knowing exactly which rules changed and which ones are still being fought over. Stay current. Get your permit if your state requires one. Know your state's sensitive location list before you carry anywhere new. And understand that this is a marathon. It took 100 years to build the May issue wall.
Entities are being protected. We need to protect people. We need to protect people. This is a good bill. It'll protect and save lives. I'm proud to support this bill. I think we all should. Time is over for thoughts and prayers.
Amendment is amended. All in favor of the amendment as amended will say aye. Aye.
Aye.
It's going to take more than a few court sessions to tear every piece of it down, but the foundation is set and it is constitutional bedrock. That's it for today, folks. See you in the next video.